Thank you, Your Honour. Your Honours, before the break, we had done a detailed review of P1529, which was Mladic's letter from March 1993, highlighting the problems which the VRS had at that point. When Perišić became VJ Chief of General Staff, some 5 months later, these problems remained unresolved. Indeed, the issues highlighted by Mladic in that letter are precisely those which were emphasised by Perišić both in his written submission to the SDC on the formation of the personnel centres and in his discussions with the SDC on the personnel centres. And the next series of slides will do a comparison between the issues as highlighted by Mladic and as addressed by Perišić in these discussions. Turning to the first issue, Mladic had highlighted the problem of morale in the VRS. And again, Your Honours will recognise this text as the text that we had previously reviewed before the break. On the topic of morale, Perišić, in his written submissions before the SDC, and that's P1872, document ID 06306544, stated that, considering the fact that VJ officers born in Bosnia and Herzegovina or Croatia who did not respond to the VRS or SVK call-up were better provided for in everything regarding service, housing, and so on, in relation to the active servicemen who stayed behind or were subsequently dispatched. We must accept that there is a reason for constant misunderstandings, various requests, and moral dilemmas with reference to these active servicemen, and problems regarding their actual obligations based on service in the VJ. Secondly, Mladic had urged the transfer of additional officers born in Bosnia and Herzegovina to the VRS, requesting that an enactment be adopted making it obligatory for those personnel to join the VRS at the request of the VRS main staff or be terminated from the VJ. Again, in Perisić's written submission on this topic, Perišić echoes, or rather responds to this need. The submission states that in the proposed order of the FRY President, to be put into effect by the VJ Chief of General Staff, all professional soldiers and civilians serving in the VJ who were born in Croatia or Bosnia and Herzegovina and sent to do their training or service in the JNA from these territories would be obliged to respond to call-up from the main staff of the Army of Republika Srpska or the Republic of Serbian Krajina, or else their service in the Yugoslav army would be terminated. On this issue of termination, Mladic's position had been very clear, stating that if they were not prepared to defend their own homeland, they would not be prepared, they would not want to fight for someone else's. This stated position by Mladic resonates throughout Perisić's statements on this topic to the SDC. At the 14th SDC session on the 11th of October 1993, Perišić stated, "If those men refuse to go there, then we need to view them as deserters who don't want to defend their homes." And that's at page 33 of P709. Later in the same session, at page 36 of the exhibit, Perišić stated, "If such an individual is not ready to go fight anywhere, and this is a single people, we need to think about whether he should be in this army at all." And then at the next SGC session, the 15th session, on the 10th of November 1993, this is P780, page 5, Perišić states, "If someone flatly refuses to go, then I'll do everything I can to help him leave the army, because if he doesn't want to defend his people when they are most threatened, when will he defend them?" Mladić had also highlighted the problem of unequal regulation of status of officers serving in the VRS and requested that an enactment be made regularising that service. Again, Perišić made repeated submissions on this issue to the SDC. With reference to those VJ officers serving in the VRS and the SVK, he stated, and this is in his written submission at P1872, "The legal position and personal status of all those persons, those who stayed behind and those who were dispatched there, has not been equally regulated regarding salary, promotion in rank and service, provision of care for the families in the fry, the right to provision of housing and other service rights." Before the 14th session of the SDC, Perišić stated, at page 32 of P709, "In order to have a foothold, we have paved the way for the President of the State, in his capacity as Supreme Commander, to issue an order regulating their status and that of officers here." And later, that same session, he emphasised that, "I'm insisting that they should get the same status as officers here." Finally, Mladić's 1993 letter had highlighted the problem of the return of officers to the VJ without VRS consent, and the impact that the drain of officers was having on VRS combat readiness and combat morale, and the need for VRS consent to be mandatory prior to an officer's return. To that end, the instructions on the personnel centres, signed by Perišić, provided for the consent of the personnel centre commander prior to the return of an officer to the VJ. These instructions are at P734, and the relevant page is page 7. And the relevant provision provides that, in keeping with service requirements, professional soldiers and civilian personnel sent or transferred to the personnel centre may be returned, assigned, or transferred to VJ units or institutions with the consent or on the recommendation of the personnel centre main staff. This provision ensured that the needs of service of the VRS and the SVK would be considered, that the drain of personnel would be prevented, and that the Army's combat readiness would be protected. The defence gives an incomplete and inaccurate account of Starčević's testimony on this particular provision of the instructions. Paragraph 264 of the defence brief cites a direct Starčević quote, and I quote, that if this paragraph stipulates that they can return to the VJ, at this point in time, they must not have been in the VJ, since this paragraph provides for their return. There is no other reasonable or legal understanding of this term." Close quote. In fact, in an exchange beginning at T6924, line 4 of the transcript, Defence Counsel had asked Mr. Starcevic, if this paragraph stipulates that they can return to the VJ, am I right in understanding it that at this point they were not in the VJ, since this paragraph provides for their return? Mr. Starcevic responded, "To put it simply, there is no other reasonable or legal understanding of this item. But if you view this paragraph separate from everything else that we have seen." Mr. Starcevic then went on to elaborate at T6925, line 2 of the transcript, that the Council has offered an interpretation for which I said there could be no other reasonable or legal understanding of this item. But if we perceive this item separate from other provisions that we have seen before, but only if we perceive this item separate.
What does that mean? I don't understand that last quotation.
Your Honours, this means that this document, in common with the other documents which the trial chamber has before it, cannot be viewed in isolation. But, and as Mr. Harman will discuss further in his submissions on Article 7.3, Mr. Starcevic testified that the personnel centres were members of the VJ as a matter of law.
Proceed.
In summary, the personnel centres proposed by Perišić addressed the needs highlighted by Mladic by formalising the support being provided by the VJ to the VRS and the SVK, by firstly creating a mechanism to staunch the flow of personnel from those armies, by ensuring that the VRS and SVK commanders could act as gatekeepers, preventing the unauthorised return of officers to the fry. Secondly, by ensuring that the rights of those officers serving in the VRS and the SVK would be fully protected and enjoyed in the same manner and scope as those of other VJ members. And thirdly, by providing the VJ, in Perisić's words, with legal cover to ensure that it could continue to transfer officers to the VRS and SVK in order to maintain and support their war efforts. Perišić was the architect of the personnel system through which the VRS and the SVK commands were provided the security of knowing that the VJ would continue to support them by providing for their officers, preventing a personnel drain, and thereby ensuring that their command structure remained solid. And the officers themselves were given the security of knowing that their livelihoods would be protected. And together, this ensured that the combat readiness and the combat morale of the VRS and SVK would be sustained. Turning to my second submission, throughout this period, however, the VJ remained the ultimate arbiter of whether an individual returned to the fry from the VRS or the SVK. The defence brief at paragraph 304 states that requests from officers in the VRS and the SVK to rejoin the VJ were decided by the VRS and SVK commander, and that Perišić played no role in the decision, nor is there any evidence that he was able to overrule and influence any decision in other armies. The purpose of the personnel centres was to sustain and to maintain the VRS and SVK officer corps. And for this reason, as we have seen, the instructions on the personnel centres provided for VRS or SVK consent prior to the return of officers to the fry. The prosecution doesn't dispute that the VRS and the SVK made the majority of decisions as to assignment to duty within those armies, and that the duties to which officers were assigned in the personnel centres reflected the decisions that had been made by the VRS and the SVK commands. And that's set out in paragraphs 176 and 183 of the prosecution brief. And, Your Honours, this is consistent with the purpose of the personnel centres, namely to supply officers in accordance with the VRS and SVK needs of service. However, it's clear from the documents and evidence that Perišić and the VJ retained the ultimate authority as to who could return to the fry. Paragraph 193 of the prosecution brief discusses P2864, which is an instruction from the VJ General Staff Personnel Administration to the 40th Personnel Centre main staff. And it provides that, dealing with the issue of officers transferring out of the 40th Personnel Centre. And this instruction provides that recommendations for transfer from the 40th Personnel Centre may be submitted only through the 40th Personnel Centre main staff and with the 40th Personnel Centre main staff commander's signature. The transfer can be executed only after reception of response approval from the VJ General Staff Personnel Administration. The examples cited by the defence at paragraph 304 of its brief all relate to instances where an officer himself requested transfer. Given the VJ's purpose in supplying the officers to the VRS and the SVK, namely to support the war effort, it's unsurprising that the approval of those officers' immediate superior was standard before they came back to the VJ or to the fry. Ultimately, however, the determination as to whether an officer stayed in the personnel centres or returned to the fry rested with the VJ, and its needs of service overrode all others. D335 is a VRS main staff personnel sector response to an officer's request for transfer out of the 30th Personnel Centre. The officer is informed that his case was discussed at the VRS Main Staff Commander Advisory Board and that a decision was made to forward your request to the 30th Personnel Centre with a proposal to the officer in charge to issue an order for transfer to the VJ outside the 30th Personnel Centre. So the VRS considered the case and decided to propose to the VJ that the officer be transferred. The VJ remained the ultimate arbiter. Equally, paragraph 192 of the prosecution brief discusses the case of VJ Major General Branislav Petrović, who had been deployed to serve in the 11th Corps in the Slavonia Baranja district. That's P2754. In this case, the Slavonia Baranja Corps Command requested to Perišić personally that Petrović be permitted to stay in the Slavonia Baranja Corps until the completion of operations in the territory. The Office of the VJ Chief of General Staff responded, stating that Petrović was required to return to duty in the VJ General Staff Air Force Administration, and his re-engagement in the defence of the Slavonia and Baranja district shall be duly regulated based on the indicators of the beginning of the aggression against this district. That is, the VJ refused the request to resend him, but informed the Slovania Baranja Corps Command that they would reconsider resending him in the event that there was aggression against it. So in summary, contrary to the defence contention, the VJ remained the ultimate arbiter as to whether individuals returned to the fray, and Perišić himself could overrule other armies' decisions. Turning to my third submission, regulation of status was vitally important. Proper record keeping, necessary to regulate status and protect status rights, was an integral function of the personnel centres. And that's acknowledged at paragraph 255 of the defence brief and paragraphs 200 and 201 of the prosecution brief. As is evident from Mladić's 1993 request, this regulation was vitally important to the effective functioning of the armies. It reassured VJ officers and their families of their livelihood, giving them security in a chaotic time and providing them both with a financial lifeline and moral support. And this enabled them to serve in the VRS and the SVK as part of the VJ assistance provided to the VRS and SVK war effort. The defence concedes in its brief that the regulation of status and the protection of status-related rights was necessary and important. The status-related rights regulated included those relating to salary, pension, housing, and promotions. And there is a wealth of evidence showing the importance of status-related rights to officers and their families, as outlined at paragraphs 201 and 209 to 210 of the prosecution brief. Defence witness Stamenko Nikolic testified that personnel records in relation to members of the VJ were exceptionally important. It's important for regulating the position and status of a member within an army. He proceeded to testify regarding the failure to keep records of those former JNA members serving in the VRS and the SVK, that those persons were facing such a situation that unless their status was resolved and the rights they enjoyed under their status, this would have utterly destroyed their families and made their survival as human beings entirely impossible. Perišić understood the importance of status regulation and the salaries being received by the officers. And in June 1994, at the 21st SDC session, that's P776, having set out the numbers of VJ officers serving in the VRS and SVK and the amounts that were allocated annually for their salaries, he stated, "That's a great help to them." In November 1994, following the Fry sanctions against the Republika Srpska, Mladić complained that stopping the salaries to VJ members serving in the VRS had caused an enormous existential crisis for their families. A situation has been created in which the attention is necessarily drawn from combat tasks. Deferring of this issue is making the matters worse for the professional soldiers of the VJ and their families. And again, defence witness Nikolic testified in relation to resolving this problem that witness Nikolic was dealing with the families at issue, he stated, "This agony went on for a full 5 months, and I have never in my life faced a crisis as severe as that." Indeed, following the imposition of these sanctions, in September 1994, Perišić sent 500,000 dinars to Mladić for salaries for VJ officers serving in the VRS, and that's P851. Actions taken by officers, including Dragomir Milosevic and Mladić, to enforce their status-related rights, including compensation for unused annual leave, injury compensation, separation allowance, and unpaid salaries, are discussed at length in paragraphs 788 to 799 of the prosecution brief. One element of this status regulation was promotions. The defence wrongly limits its analysis or its discussion of promotions in the VJ to a 7.3 context. However, promotions and their regulation were also a clear component of the assistance provided by Perišić under Article 7.1. The defence argues that promotions of VJ officers serving in the VRS were made final in the VRS, and that the only steps taken in the VJ were to verify those promotions to regulate the status rights of an officer. This is incorrect, and Perisić's active role in this regard will be discussed by Mr. Harman in the context of his submissions on Article 7.3. However, the defence accepts at paragraph 383 of its brief that an officer's rank formed part of the basis of payment for increased salary and other attendant benefits such as pension entitlements. The defence also accepts at paragraph 415 to 420 of its brief that any change in salary, pension contributions, housing priorities, or other status-related rights only became effective when a VJ officer was promoted in the VJ. And as with the other elements of status regulation, this was important to officers serving in the VRS. For example, in Galic's VRS exit interview at P1760 on the 12th of August 1994, the first point that Galic made was, "Before the adoption of a decision on the termination of my professional military service, I wish my appointment to my current post of Commander of the SRK, Establishment Rank Lieutenant General, PG4 rank group, to be verified." Promotions were also good for morale, and Perišić strongly advocated for promotions of VJ officers serving in the VRS and the SVK on that basis. At the 15th SDC session on the 10th of November 1993, and that's P780, page 23, Perišić stated in relation to promotions, "We'll be giving them moral support. It's not just the matter of a flat or something like that. These men are fighting, and by doing so, they're ensuring peace to us. I urge, and that's why I proposed, that they be given this, since it would greatly motivate them. In doing so, we would recognise what they have done." In summary, Your Honours, the regulation of status-related rights relating to salary, pension, housing and promotions, and the security of access to those rights, enabled VJ officers to serve in the VRS and the SVK for as long as they were so regulated. It gave the officers serving in the VRS the comfort to stay as long as they were needed, in the knowledge that they weren't giving up their VJ benefits. no such security was available for former JNA officers serving in the ABIH or the HVO. Through sustaining and maintaining the VRS Officer Corps, the assistance provided through the personnel centres had a substantial effect on the crimes committed in Sarajevo and Srebrenica. That concludes my submissions on the personnel centres, Your Honours. Unless you have any further questions, I will hand over to my colleague, Mr. Thomas. Excuse me, one moment, Your Honours. My apologies, Your Honours. Mr. Harman has just pointed out an error in the transcript, which is at page 62, line 16. And it currently states that personnel centres were members of the VJ as a matter of law. And it should, of course, read that persons serving in the personnel centres were members of the VJ as a matter of law.
Thank you, Madam McKenna.
Again, unless Your Honours have any questions, I will hand over to my colleague, Mr. Thomas, who will make submissions on the second element of the assistance provided by Perišić, namely logistical and material assistance.
Judge, do you have any questions? Thank you very much, Madam McKenna.
Thank you, Your Honours.
Thank you, Mr. Thomas.
Your Honours, in the time left before we break, I will endeavour to discuss the aspects of the logistics case, namely the assistance provided by the VJ to the VRS in weapons, ammunition and other logistics assistance. In doing so, I don't propose to discuss the prosecution case in any detail. I don't wish to summarise it in any way. The prosecution allegations are substantiated by an analysis of the wealth of evidence that has been tendered in this case and which is described in our final trial brief. We don't seek to augment that analysis or qualify that analysis in any way today. What I would like to do, Your Honours, however, is just to take the opportunity to address a number of misconceptions under which the defence appear to be operating when it comes to this part of the case. The first of those is the interrelationship between the VJ and the FRI Ministry of Defence. The defence have made the assertion that in the budget planning and production phase, namely the phase during which funds are being made available for the VJ and production requirements are being assessed and paid for, the defence have asserted that during this period the VJ is operating or was operating under the authority of the MOD, the FRI MOD. And that assertion, Your Honours, is found at paragraph 613 of the defence final trial brief. That misstates the true relationship between the VJ and the FRI Ministry of Defence. At the time that General Perišić took his position as Chief of the General Staff, there had been the restructure of the Federal Secretariat of National Defence, and as a result of that restructure, the VJ and the FRI MOD neither the VJ nor the MOD were subordinated to the other. In practical terms, what that meant was that the FRI MOD had the responsibility for submitting a national defence budget to the FRI Assembly. For the purposes of that national defence budget, well, let me go back a step, Your Honours. The national defence budget provided for the VJ requirements and it provided for the FRI MOD requirements. In other words, funds were put aside for the functioning of both the VJ and the functioning of the MOD in the national defence budget. By far, the larger component of the national defence budget was to meet VJ needs. Although the MOD was responsible for preparing the draft national defence budget, because the vast proportion of the VJ national budget went to providing for VJ needs, it would seek from the VJ General Staff a draft VJ budget plan. The VJ would essentially provide a submission to the FRI MOD seeking funds for its operations. That was prepared by the General Staff of the VJ. In it, they would seek funds for the coming year for all of their needs. The single biggest need was salary. Well, the single biggest need during the indictment period was the payment of salaries. And incorporated in that request for funds for salaries from the VJ included the amounts that were payable to VJ officers serving in the 30th and 40th Personnel Centres. Also sought by the VJ General Staff in its budget plans would be the other requirements or its other needs for it to properly function, including the replenishments of its reserves. Once the VJ General Staff had prepared that budget plan and it was forwarded to the FRI Ministry of Defence, we've heard evidence that there would on occasion be discussion as to whether or not that VJ budget plan was realistic. In other words, whether given the state of the FRI at that time, that the FRI Assembly would likely pass a budget that contained such requests, or whether the VJ budget plan would need to be amended to make it a little more realistic in that respect. However, ultimately, the two entities reached a position where the VJ budget plan for the coming year had been submitted by the General Staff to the MOD. The MOD incorporated it in the draft National Defence budget, which was then sent for approval to the FRI Assembly. Once the FRI Assembly approved the budget, the MOD was responsible for dispersing funds against that budget in large measure. In particular, the MOD was responsible for dispersing the individual salaries to the individual officers concerned. But, of course, this was against the funds put aside for that purpose in the National Defence budget as requested by the General Staff. The FRI MOD was also responsible for ensuring that the funds that had been approved for the replenishment of VJ reserves were put to that purpose. And in practical terms, that meant that the FRI MOD would arrange for the necessary production from the special purpose industry facilities that Your Honours have heard about during the course of this trial. And those special purpose industries, being subordinated to the Ministry of Defence, would produce the necessary material, and upon production of that material, it would be sent to the VJ to replenish VJ reserves. Now, the evidence on all of that comes from two defence witnesses, General Stamenko Nikolic, who was the FRI MOD Head of Administration for Systems and Status-Related Affairs, and General Jovanic, who was the FRI MOD Head of Finance and Budget Administration. General Nikolic also provided, Your Honours, a piece of evidence that corroborates other evidence in this trial, but which is important when it comes to the logistics case. Because notwithstanding that relationship between the VJ and the MOD, once material that had been produced by Fry Special Purpose Industry formed part of VJ reserves, it came under the control of General Perišić. It was General Perišić, as Chief of the General Staff, who had authority to decide the use to which the VJ reserves would be put. And it's important, Your Honours, when we look at P1009, which we could have on the screen for a moment, to view the document in that context. And Your Honours will recall this document from Mr. Harmon's presentation and also from the occasions that we have seen it during the course of this trial. This is the order where the 30th this is the order where President Lilić authorises the Yugoslav Army, not the MOD, but the Yugoslav Army, to supply the 30th and 40th personnel centres with weapons and military equipment. And this is where President Lilić authorises General Perišić to regulate the requests submitted to the VJ by the VRS and the SVK with the means of the VJ to fulfil those requests from the reserves which he had authority over. This order exists, Your Honour, because General Perišić asked for it. General Perišić knew full well his legal obligations and the state of the law when it came to dispersing military equipment. He understood that he had no right to send military equipment, weapons and ammunition, to another army. He understood that the material wasn't his to give in the first place, because ownership of it vested in the Ministry of Defence. Nevertheless, it was he who advocated for the issue of this order so that the Yugoslav Army could provide this material to the 30th and 40th personnel centres, and so that he could control that process. This comes from the 18th session of the Supreme Defence Council. At a session on the 7th of February 1994, which preceded by a matter of days the order being issued by President Lilić. And if we can move please to the first highlighted section. Thank you. And this is General Perišić, Your Honours, addressing the members of the SDC. They're discussing the provision of assistance to the SVK and the VRS, or specifically the provision of VJ assistance to the VRS and the SVK. He states, the property law which entered into force does not give the Chief of General Staff any right to misappropriate any resource, especially in terms of assistance, and specifically now to Republika Srpska and the Republic of Serbia and Krajina.
Can we put a sick after misappropriation?
Yes.
Thank you.
Can we move to the second part of the quote, please? Either things should remain the way they are regulated by law, in other words, I can't send it, or the Supreme Council should adopt a decision to authorise me to give them something that this body decides upon. So, they make a request to the Supreme Council. I convey it to you and say whether this is justified or not. You make a decision, and then it is implemented by the Chief of the General Staff. This is the way I propose, because